He's the great David Katz, everyone. David, hello,
How you
sir.
doing?
Thank you for joining us. Wow, there's so much to get to. I want to get right in. This 14th Amendment thing has picked up momentum. It was originally, I think you look good with the tie loose like that. You look like a working attorney.
Okay.
Which is what you are, and I appreciate you taking time out to talk to us. So this 14th Amendment has increasingly gained momentum. The constitutional argument suggesting that Donald Trump could be removed from or shouldn't appear on ballots nationwide because of his insurrectionist leanings and what he's been involved in. And I wonder if you could just set the bar for what would be possible and how likely it is to happen and how it would go state by state, is what I was saying before.
Well, I thought that the Mueller investigation was going to go somewhere, as you may recall. And then we had the January 6th hearings and all of that. And so I don't mean to seem pessimistic about this getting the goal of Trump not being able to run, but I'm very pessimistic about that because there's a couple of things to take into consideration. And a little bit of it is the history. You know, we had a true insurrection. You know, we had a civil war and we had the secessionists who actually left the Union. And they were very proud of it, and they signed things, and there was all this proof that they were secessionists. And then when they tried to get right back into power after the Civil War, you know, rejoin the Union, there were obviously questions about whether some of these secessionists should be allowed to run for federal office, for state office, and so forth. And then there was actually an amnesty because, as people will recall, you know, unfortunately, Reconstruction kind of ended up going nowhere. We had Jim Crow in the South for all those years. And there were amnesties for the insurrectionists. And so they were allowed to pretty much rejoin government. So some people say that all of that law about the 14th Amendment and about excluding insurrectionists is really not even in force, even if you had some proof, you know, a compelling proof, you know, legal proof that Trump was fomenting the insurrection, part of the insurrection. Even that wouldn't bar him because the law doesn't mean what people think that it means. Putting all of that aside, they don't have proof. They don't have, Mark, a criminal conviction of Trump for insurrection. They don't even have a civil finding, you know, that's been appealed and been through the system that he's liable for insurrection and for not tamping it down. So while all of us have seen this in real time, you know, we saw this on January 6th, that he didn't tamp it down. We saw what happened. We saw the marauding. We saw the speech that he gave. Can you really just say one time, go peacefully, and that exonerates you from every inflammatory, incendiary statement that you made and that you had your cronies make? But the problem is that there's no proof. And at the end of the day, even looking at it, you know, we've talked about this, that after Merrick Garland finally got around to putting in a special counsel, even the special counsel did not file any charge which was scarily Trump fomented and incited the insurrection. Trump sat back and committed an affirmative act of insurrection by not tamping down the insurrection for 3.5 hours. He sent out an incendiary note while it was going on about Pence. But he's not even charged with any of that kind of stuff. So the idea that someone is really going to make a successful petition to the Secretary of State, a Democrat in Colorado, and have him keep Trump's name off the ballot, Trump will litigate it. He'll probably win. He'll probably crow endlessly about his victory against the Democrats, who are again engaged in election interference, trying to keep his name off the Republican ballot. And then I think in the final election, you know, if it ends up being Trump against Biden, I just don't think that there's a basis, Mark, to keep his name off the ballot, because by that time he will not have been convicted or had even a civil finding that he engaged in insurrectionary acts. We kind of all know that he did it, but we have a legal process. And the last thing is that this is a slippery slope. If you start to go down this road, I mean, what's Colorado supposed to do? Have an evidentiary hearing at which they're going to determine whether he was or was not, you know, inciting insurrection or participating in insurrection. So the one person who's actually been excluded was someone who was criminally convicted of insurrection. And the judge said that he would be excluded from holding federal office. I don't think he even bothered to appeal. That makes a lot of sense. But Mark, you can see legally how different that is from some Secretary of State being asked to take Trump's name off of some ballot, either for the Republican nomination or in the general election? And what would be the legal basis for doing so? And how would it possibly stand up, since that would be appealed? And there'd be a huge legal effort and expense by Trump to beat that. And some poor state secretary of state's office would be defending it. And so I just don't think that this is a road that they ought to go down. And I know that some professors said that, and they have a lot more degrees than I do, and they have academic tenure and everything else. But, that's why I think sometimes, frankly, the opinions that I express are more really grounded and down to earth and right, not wrong, rather than, right or left, because I think that they've got this sort of, I think, what do they call it, where they all say the same thing, they have that group think, that group speak in some of these academic institutions. I mean, I just think that they do, and that the two professors from very esteemed legal schools wrote this opinion piece. I don't think that it stands up, and I don't think it's going to happen. And I think people should put their efforts. I used to say this with Pat all the time: organize, vote, beat Trump at the polls.
Yeah. I mean, you make such good points, and you do always just call balls and strikes, which is one of the reasons we like talking to you. But it's weird how just that conversation, and then I do want to move on, but that conversation around this, and the crew, the Ethics in Washington group, Citizens for Responsibility and Ethics in Washington, they sued, and they are suing in Colorado court to have Trump declared ineligible. And then the conversation, because of, as you said, these two Federalist Society guys, so they're right wingers, making this point that he should be removed. This begins to feed a rhetorical momentum. Then the question is asked in media, and you have in Arizona the Secretary of State saying, "Hey, I'm not sure, we haven't decided on this." You have in Michigan them talking about it as well. I mean, again, they're dignifying it with a conversation. They are not dismissing it out of hand, and that creates its own momentum. So I think that's what's kind of happening nationally right now.
So you need a stronger record. You need a stronger record than that we sort of all saw it and we know what happened. You need a stronger record that he actually engaged in insurrection.
What happened in court yesterday is there was an attempt to, is it called severing the case, where you're separating yourself? I wonder if you could speak to that yesterday's.
That one didn't get reported very well because it's real inside baseball, and it's what I do for a living. What I've done as a federal prosecutor, this is like the meat and potatoes. And usually, you talk about a cocktail party and people's eyes just glaze over. But when it's Trump and his minions, it really is interesting stuff. So I think that this Bonnie Willis down there made a huge mistake. I guess it's going to help her get reelected, but to charge all 19 together. And then she adamantly stands around and says she's somehow going to try all 19 together. And everybody says the emperor has no clothes. You are not going to try 19 together. Why don't you get off it and figure out a way that really makes sense? Different bins. Maybe you're going to try 6, and here's why those 6 are related. Try another 5, and that's why those 5 are related. But insisting that there's 19 is really preposterous. And I think people who are calling balls and strikes are saying so. So what's happened is that 2 or 3 of them were federal employees at the time they got a federal paycheck. That's former White House Chief of Staff Meadows. That's Jeffrey Clark, number 5 or 6 official at the Department of Justice in Washington, who supposedly was going to help Trump. He was going to vault over the others, and he was going to issue the opinion that there was monkey business in the election, and then the Republican Congress members were going to take it from there. He was more than willing to do that. Everyone else threatened to resign, and Trump at the last minute said, "You know what, this is not going to end up working out." So he didn't, he pulled the string at the last minute on this guy Clark. And there's 1 or 2 others who are federal employees, not deputized, not Giuliani was the president's private lawyer, but who were actually real federal employees, got a paycheck at the time. I believe ultimately they're going to go to federal court. And that's confused people because there's a part of this case that I think is going to go to federal court. The judge speculated at the televised hearing. Does that mean everybody goes to federal court? It's an interesting question. I think at the end of the day, the others do not go to federal court unless they make a motion for removal. I don't think all 19 get removed because 2 get removed. So I think the 2 probably hard call probably end up being removed. That leaves the 17 in state court. Those who remain in state court have a right under the Georgia Speedy Trial Act to a truly speedy trial. It's not like the Federal Speedy Trial Act for people who know that, or lawyers out there, or people who've had relative who is involved in this. You don't have a true right to a speedy trial in federal court because it's a right subject to excludable time. And first of all, almost every defendant wants excludable time. Everyone says they want a speedy trial, but what they mean is a speedy trial if it goes my way. If it's a speedy trial that goes God only knows what way, they say, I'm out on bail, I'm living my life, why don't we kick the can down the road, right? But you've got a guy, this Cheeseborough, no one knows how to say his name, even his own lawyers, but I'm going to say Cheeseborough because that's what rolls off my tongue. This Cheeseborough guy is the rare guy. He has quite an esteemed background. I think this is the guy who went to Harvard Law School, and he worked along with Professor Tribe on the Gore challenge. So he really knows something about these presidential challenges. But the idea is that this was such an outrageous opinion about these alternate electors that he couldn't have really believed it. He had to this is sort of the dark arts of constitutional law, Mark, and that he was smart enough to know this issue so well to know that his advice was BS. And that's actually going to be fairly hard to prove. It's going to be a very interesting case. And he hoped that he was going to get his reputation back, have this early trial. I don't know whether he's getting funds from one of these PACs or something, but think how it's in their interest. If the headline were, Trump lawyer, one of the 19 actually went to a trial and won, was acquitted. Forget what the issues were. Forget who the defendant was. Just think of that as an optic. Think of that as a propaganda point for Trump. So I think the idea was that everybody was pretty happy. Everybody. I mean, Trump was happy, and this guy was happy that he was going to go to trial. They'd have a preview of the whole trial. And the funny thing about it was he's got severed from the others. He's going to have his own speedy trial if he sticks to his guns and really gets ready by October 23rd. But this Sidney Powell ended up deciding she wanted the same thing. And she's widely perceived as a nut. As somebody said, Cheeseborough had a great strategy until he got linked to a lunatic. So he is now linked to a lunatic, namely this Sidney Powell, and he's looking at going to trial with her. So he wanted to get away from the others and also away from her. He got severed from the others. He didn't get severed from her. That's going to be a really interesting televised trial if it goes on October 23rd.
Well, she truly was serving up the wildest various scenarios that she claimed she had evidence for. So now I really want to even more maybe get into the weeds with you. So tell me why he couldn't successfully sever himself from Sidney Powell. Why did the judge potentially say, no, you two together, is it because you did the same dance? I mean, you've kind of described the distinction between them, but it must be some similarities, right?
Their lawyers did a really good job of describing the similarities, basically saying that this is an issue of constitutional interpretation with experts, the Cheeseborough trial, and then the argument that no, there'll be so many people who disagreed with Cheeseborough, so many people who said that Cheeseborough was putting the cart before the horse. He's getting alternate, slates when there's no basis to have an alternate slates. The alternate slates are for when you are winning something or you're on the verge of winning something. And it's like, wait a second, if this judge really does knock out the Biden slate, who's gonna vote for Trump? There is no Trump slate. We need to have an alternate slate ready to go if we win in court. But this was being done at a time when they'd lost 60 challenges in court. They were not on the verge of winning either in court, Mark, or even winning in front of the state legislatures, not even the Republican state legislatures or the Republican office holders who wouldn't stick their neck out that far for Trump. Cheeseborough apparently would stick his neck out that far. It's going to be a really tough trial. That one could go either way, sort of academic, not Sidney Powell. Sidney Powell, her whole, like you said, her whole thing, Hugo Chavez, and, he set this thing in motion, and Dominion supposedly got these machines, and they were being put in all these different states. And whenever you cast a vote for Trump, it registered a vote for Biden. Of course, it didn't malfunction for any of the Republican office seekers who won, but it malfunctioned just it was all craziness. What she actually did in Georgia, supposedly, was she went to this little county down there after January 6th, after even the diehards knew that the war was over and that they had lost and the transition was on. This was a desperate last move to, I think they're saying down there in Georgia, the prosecutors are, to actually seize some of the machines and to show from the machines that supposedly this Hugo Chavez thing kicked in on the machines, to prove this old point that they'd been bandying about that they never had evidence for. And that she had to do with that. You could see how dissimilar the two of those are. But to answer your question, it comes down to the judge's discretion. This idea of whether the judge is going to sever two people from each other. There's a lot of discretion. Most judges don't want to do it because it means that they have two trials instead of one trial for two people. They have two trials for two people. If it's the same judge and they're saying it's going to be a very long trial, it's, that's all the judge does. He tries a 4-month trial and then he tries another 4-month trial. Now, I want to talk about this point because I think it's so important, Mark, about what happened. This is why I don't like RICO. This is why I think that the Georgia legislature will go back and deal with RICO. RICO is a monster, okay? And the argument's made clear what a monster it truly is. By charging RICO, by charging this racketeering enterprise, the prosecutor's position is that they're entitled to show this racketeering enterprise, all of it, beginning to end, everyone who was in it. So at a minimum, it means that if you've only done a minimal number of things, you have to sit for a 4 or 5 month trial. Maybe you have a life, okay? But that's 4 or 5 months. Most people don't want to waive their appearance. I mean, they're going to be, charged with a felony or convicted of a felony. Maybe they're going to be sentenced to 5 years in prison. You don't have anything more important to do. But the reality is you should have a 1 or 2 week trial if the events that really pertain to you are things that can be tried in a week or two, not go for a 4 or 5 month trial. How can any normal person pay an attorney for a 4 or 5 month trial? Start to add up the billable hours, right? Day after day after day of having this lawyer in trial. And they insist that they're entitled to put that on, even in a severed trial. Now, that to me, that can't be the law. I think a judge can always decide that evidence is more prejudicial than probative. And if it all has to do with other people that you don't know, that you had nothing to do with, the fact that you were in this enterprise to a very small extent doesn't mean that they have a right to show the entire enterprise and drag everybody that they charge, innocent until proven guilty, through a 5 or 6 month trial. And one last thing I want to say, this prediction that this is going to be a 4-month trial, I don't believe it, because when Phony Willis went after the school teachers over the cheating scandal, which when you think about it is a pretty weird, just off the bat, you go up to a person on the street and say they all got charged with being racketeers. They go, excuse me? I must have heard you wrong. They all got charged with racketeers, these school teachers? But they did. That trial was 8 months, Mark, and it wasn't with 19 people. So that's the thing about this Phony Willis. She's starting to sort of hit people as someone with a political agenda to get herself reelected and to make all of these claims, including in court, that can't possibly be right. So it'll be very, very interesting to see if this speedy trial really happens, this televised trial. But I warn people, it may be not only very long, very boring, but it may have an acquittal at least of Cheeseborough. I wouldn't bet on Sidney Powell. So there's my Katsadamus. There's my Katsadamus.
That's our Katsadamus for today.
Maybe Cheeseborough, don't bet on Powell to win anything.
Boy, you make such a good point about RICO generally, because we're not typically exposed to what's involved here. We're all learning about RICO. We know that I think they got Al Capone that way. They got other mobsters that way. They've got big drug dealers that way, right? But in this case, as you say, the underlings, the guy who was just asked to move a box or whatever, or to in this case, surrender or erase certain materials, whatever. That guy, who is a person who's making, middle class wage, now has to lawyer up and show up. Is it a way? And then I want to move on from this. But is it a way to extract testimony and flipping from some of those people, the lower on the rung kind of people? It seems like it's almost designed for that.
Well, it's designed to get them to cooperate really unfairly. I mean, think about a person who's innocent. Let's go with the cornerstone of our liberty, what we fought a revolution over, all those kinds of things, right?
Sure.
This is what makes America great, that the fact that the government wants to get you, number one, they can't interrogate you. You have a right under the Fifth Amendment. I say this to my clients from other countries, and that's just something that they don't have in other countries. We have it in America. They cannot interrogate you and make you answer. You can say, I have a right under the Fifth Amendment not to answer your questions. Talk to my lawyer. Of course, your lawyer's not going to talk about the case either, the particulars of the facts. But that you have this Fifth Amendment right is so important, and that you're presumed innocent is so important. And, I totally get it. Trump has gotten away with everything. And now all of a sudden, people like me who are civil libertarians point these things out. And it's like, but yeah, okay, so Trump's going to get away with it again? A friend called me on the phone. I don't know if I can, I'll use the word. Let's say the word in Yiddish is a jerk, okay? this jerk's going to get away with it. Why do you go on TV and say this jerk may actually get away with it? Well, because this jerk has the same rights that other people do. And that is the strength of America, that this jerk has the same rights that other people do. And, he never treated people, in my opinion, fairly. He was more than happy to railroad people. He was more than happy to get people. I still want to know how his two enemies at the FBI got picked for the most intrusive IRS audits ever. There's a mathematical chance, 1 in 7 million, that they both got picked for that kind of an audit. So I know Trump loved to dish it out. He loved to dish it out dirty, unconstitutional, vindictive. But, the greatness of our country is that he gets due process.
Go ahead, Kim, and then I have a follow-up.
I'm going to lose so badly right now because I'm going to try to challenge David Katz, and I'm going down. I know that going into it. But I'm thinking about the 14th Amendment. And to my knowledge, it doesn't say you have to be convicted of insurrection or you have to have been found guilty in a court of law, right? Whatever designation that any state wants to use to say, you're an insurrectionist, we choose to kick you off the ballot. Here's what I wonder. And whether that's right or wrong, you can argue. You could say maybe we need to have a conviction, fine, but we don't right now. That's not the rule. So say Colorado, as an example, kicks Trump off the ballot. He sues, but by the time he sues, it's too late. The vote has happened. His name wasn't on it, which means he loses the election. What I'm wondering is if it's worth the lawsuit that will follow thereafter, because we've seen Republicans play extraordinarily dirty. So maybe it's time for Democrats to play dirty like this as well. The entire nation will then thank that state that keeps this horrible person from further destroying our country. Is that not worth it? Could that not happen?
Well, number one, I just don't think it's a legal matter that it will end up, happening. I just don't think so, Kim. I don't like the precedent in general. I mean, somebody could decide that, I don't know, you remember the protests after George Floyd was killed, right? And you could certainly argue that the thing in Portland, Oregon got to the level of an insurrection, and so did some of the others, right? And that anybody who was okay with that, right, okay with that supposed insurrection, you're going to not let those city council members run again. You're going to not let all these people run. I mean, someone's opinion of what causes an insurrection, it seems to me that's very hard for a municipal authority or a state authority to say, okay, those are the standards, okay? So if Colorado says, Kim, we decide that standard. We decide who's an insurrectionist, okay? First of all, it's not the easiest term in the world. I think the other thing is rebellion, Those seem to have kind of the definitions they had in the 19th century. But if you say that the marauding of the Capitol was an insurrection, it was a rebellion, right? That sort of, it makes you think more of the Civil War, what they did as being an insurrection and a rebellion. Mm-hmm. So I'm not sure that it really fits. But I guess the problem is, how would you adjudicate it? And this idea that things go slow, when Trump wants litigation to go slow, it seems to, the clock starts to go backwards. It took 2 years and something and 2 trips to the U.S. Supreme Court to get his income tax records, okay? But when he wants it to go fast, it can go very, very fast. He'll have great lawyers. They'll jump right on this. This will not be decided sometime after the election. This will be decided the next day with a request for a temporary restraining order allowing his name to be on the ballot. And if the officials wait until the last minute and try to issue their order and keep his name off the printed ballot, they'll look terrible. So they'll have to decide very soon, let's say 2 months before the ballot gets printed, he'll have his motion for a temporary restraining order the next day. That will also go to federal court because I think at the end of the day, it's for a federal election. He'll say it determines who has the federal nomination. So I think a federal court will rule in his favor. And the Supreme Court, he has at least 6 votes on the U.S. Supreme Court, to which it will get to very, very fast. And whichever Secretary of State will not be thanked by the grateful public who kept this maniac out of the White House yet another time. Thank you, Lord. Okay. I think it'll be just another, election interference. The Democrats try to, pull the wool over your eyes, but the courts figured it out.
That'll be the media spin, but you're making the bigger point, which is that legally it just won't stand up.
It won't work. It won't work, Mark.
It won't work.
I'm looking at, though, it shouldn't have worked for Republicans to say, oh, we have a lame duck president. We don't consider your Supreme Court nominee, that you've put forward because we don't think you have enough time left in office for it to matter. So if you look at the way that played out, then maybe making this declaration that Trump's name is off the ballot, the day before it goes to print, it might be a bad look, but hey, they play dirty. Why not?
They do throw heat. They're ruthless. It's true.
Kim, I had thoughts on that one too, and I haven't really had a lot of time to prepare my argument on this. But since we're talking about it, I wondered whether Obama should have said to McConnell, "Okay, you don't really understand that I'm willing to play hardball on this. Okay, so in a month from now, I'm going to put Merrick Garland on the U.S. Supreme Court with a recess nomination. We're going to have 5 votes to 4, the first time the Democrats would have had it in decades. Okay." And then until something else happened, I guess until the end of the term. Now, McConnell would have tried to counter move and say, well, we're not really in recess. You're not allowed to make a recess appointment. If Merrick Garland wouldn't have done it because he's such an institutionalist, he would have said, well, I don't want to be in the middle of a controversy like that. Then Obama says, look, I have a wonderful, young, brilliant lawyer that I am going to put on the U.S. Supreme Court. Believe me, in all of America, he would have found a young, brilliant, liberal lawyer who would have been willing to be a recess appointee to the U.S. Supreme Court and say, well, that's it. I'm going to put that person on there, and the person's going to start ruling on cases. And I don't think there would have been anybody to remove that person. Who's going to remove the recess appointment on the theory that he wasn't entitled to make a recess appointment at that moment? Guess what? He'd have 5 votes on the U.S. Supreme Court against 4 that would say the recess appointment was just fine, including that young attorney who would have been on there. That was not Obama. That was not the president that we had. He had so many, I thought, virtues and good things about him. If you wanted that kind of combativeness, it wasn't there. And then he was, he also wasn't willing to, you can imagine LBJ, suddenly there wouldn't have been a single delivery in the state of Kentucky, right? All the federal governors would have gone completely around the state of Kentucky. He would have gotten into it with McConnell, but that was also not something that Obama was going to do, and maybe not something that he should have done.
Right.
No, this is so great. I love that take, and I've not heard it before. And I want to ask you a quick follow-up on that. Just with a recess appointment to the Supreme Court, what would have been required for removal of that justice?
We can talk about that next time. I haven't researched it that much, but it would seem to me. I mean, what would happen? I guess Roberts.
You'd need a Senate vote, wouldn't you?
He could. No, the recess appointment. You see, the idea in the old days, they actually took normal recesses. Now they try not to recess. They try to have somebody. Right? McConnell would have tried to have somebody sitting there burning the midnight oil, so that the Senate would never recess. So he would have the position that it was invalid. And then I guess you would have had, Roberts would have had to swear him in or not swear him in. And if Roberts hadn't have sworn him in, I guess Sotomayor would have sworn him in, and he would have shown up. What would they have done? Roberts would have called the marshals and not seated him. He probably would have been seated. And he would have been, and then they would have tried to pay him back by never confirming him, right? And Merrick Garland would have figured that many chess moves ahead and figured, well, this is my chance to be on the Supreme Court for some months. But like that was just not something that Obama.
Right. It was not. It took a level of political aggression that Obama just didn't have. I think it's a really great point. The last thing I want to say about removing Trump from and you've kind of hinted at it, is, and I think you've all but said it explicitly, is, hey, if you do remove Trump, if you do just decide, because Kim's right, it doesn't have to actually be some kind of a civil judgment or even, in a court of verdict. You just decide that he's an insurrectionist or that he aided insurrection or whatever you want to say. If you remove him, whatever Secretary of State that is, you've set a precedent, and you've kind of said this, David Katz, for Democrats to be removed. Joe Biden can be removed from states. I mean, they're going to argue. They don't have to argue anything in terms of a court case, as you suggested. They just have to decide and surmise, in air quotes, that Joe Biden is corrupt and therefore has violated the Constitution, and in that way he shouldn't be on the ballot. You see how it could really turn into an ugly mess.
I do, and it would be reviewed by a federal court. And so it's not like the Secretary of State's ruling, even in a blue state, would stand up. And of course, if it's in a blue state, that's a state that ultimately Trump is going to lose. So Trump's not going to be relying on winning Colorado anyway. I think the way it matches up now, the rubber really hits the road It's always the same states:
Yeah,
Arizona,
right.
Georgia, North
Wisconsin.
Carolina, Pennsylvania, Wisconsin, and Michigan. Right? We have an election in 7 states.
All right. Gosh, you're way over time. You've been great. Do you want to touch on Murdoch real quick, or is that interesting to you, or on the
The
way
only
out?
thing I want to say about Alec Murdoch down there in South Carolina is that
Yeah.
I was with a federal judge, for about 14 months in Washington, D.C. We had a lot of trials. At the end of the trial, there's a marshal who stands up in the courtroom, and the judge reads a little script which says, "Do you swear that you will keep this jury apart from any outside influence, not let anybody speak to this jury about any matter whatsoever?" And I don't know, did that not happen? Was there not a marshal to make sure that this court clerk didn't tamper with anybody on the jury? Having said all of this, I don't think that he's going to be granted a new trial. I think they're going to say this was a harmless error. But of course, the defense is claiming in this request for a new trial for Murdoch, the man down there, the lawyer from the famous legal family in South Carolina, who was convicted, found guilty by the jury and sentenced for murdering not only his wife, but one of his sons. So it was a spectacular, tabloid type case that, a lot of people were watching all the time on TV. I don't think he's going to be granted a new trial, but it's just really remarkable that someone could tamper with the jury. And people were really shocked. If you remember, they went out on Friday around 6 o'clock and they came back at around 8 or 8:30. No one expected them to come back in 2.5 hours. And this court clerk supposedly said to them, we're going to put you in a hotel tonight if you're still deliberating after 11. And they said, put us in a hotel. Nobody warned us. We didn't even bring an overnight bag. So if she stampeded that jury, and they can show that to a court, also difficult to show jury misconduct, but I won't get into all of that. God only knows. I mean, this may be like a big flop, but I think at the end, no new trial.
No new trial. Okay. And again, it's not because there was no. It's not a double jeopardy situation. If you were acquitted, it would be double jeopardy situation. But not, isn't that right? So
yeah, he could get a new trial, but of course, it was
the evidence is overwhelming.
But Mark, anything could happen at a trial. You could have a hung jury. You could have something. You know what I mean? From the prosecution's point of view. They consider every conviction like a gem. They got it. They want to preserve it. They want to, fight like hell not to have a new trial, because anything can happen at a trial, even with a great weight of evidence, especially a hung jury can happen.
Boy, David, have I kept you over time. Thank you so much. The great David Katz joins us on Thursdays. Thank you, sir. You're so generous with your time. And let's just review again. Katzadamus says, there will be a no 14th Amendment. I thought you also had a prediction on the.
It will not succeed. It will not succeed in any state. It will not keep Trump's name off the ballot for the nomination or in the general election in any state, in my opinion. And also, I think Cheeseborough, you might get some action on whether his case gets severed and he gets actually found not guilty. Right. Don't bet any of your hard-earned money on Sidney Powell to win anything.
All right, David Katz, thanks so much, my friend. David Katz, everybody.
Kim, I'm glad I didn't have you. Kim, I'm glad I didn't have you in moot court. Kim, I'm glad I didn't have you in moot court.
Yeah, Kim was tough today.
Oh
Kim
no, I'll fall to Katz every time, but I'll go down
trying at least. I don't know about that.
Thanks, David. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.